If your child is suspended from school, there are certain rights and procedures that you should know about. First, find out if it's a principal suspension or a superintendent suspension. A principal suspension can be for anywhere between 1 to 5 school days. The principal must provide you with written notice of the suspension before it starts and has to hold a conference with the parent within 5 school days. At that conference, you will have the opportunity to see any evidence or hear any witnesses who have information about the incident, and you'll have a chance to ask questions at that time. The principal will then make a decision about whether the suspension should be upheld or dismissed. A superintendent suspension is much more serious and can last anywhere from 5 days to 1 year. Again, the school must provide you with written notice of the suspension. There will be a hearing scheduled within 5 school days. You can ask for an adjournment or a postponement of the suspension hearing if you need more time to prepare for it. Before the hearing, you should ask the school for a copy of the suspension packet. The suspension packet contains copies of any witness statements and evidence there is about the incident. These documents will help you prepare your case. After you look at the suspension packet, you can decide whether you want to go forward with a full hearing or enter a no contest plea. If you decide to go forward with a full hearing, the Department of Education bears the burden of proof and has to convince the hearing officer that your child did what he's accused of doing. The school can present witnesses and evidence, and you will have an opportunity to cross-examine those witnesses. You can also bring your own witnesses and evidence to help show your child's innocence. If your child has been arrested for the same incident that led to the suspension, your child should not testify at the hearing. Anything your child says at the hearing could be used against your child at a juvenile delinquency proceeding or a criminal court proceeding. After the hearing is over, the hearing officer has 2 school days to make a decision about the case. You will receive a written decision that says whether the suspension has been upheld or dismissed, and it will also say when your child can return to school. If you're unhappy with the decision, you have the right to appeal it to the chancellor. During any suspension, the school must provide your child with alternate instruction. Your child cannot be penalized academically during the course of the suspension. That means that the school must provide your child with his regular schoolwork and must give your child an opportunity to take any tests or exams that fall during the period of the suspension. You may bring an attorney with you to the suspension hearing. If your child has been arrested and is represented by the Legal Aid Society, legal aid may be able to help you with the suspension hearing as well. If your child has not been arrested or is not represented by the Legal Aid Society, ask the Department of Education to provide you with a list of free or low-cost attorneys who can help you at the suspension hearing.